Hey everybody, Justin Stivers, owner of the Probate Law Firm here, probatefirm.com. Thank you guys for tuning in. This is the second episode where we're talking about probate. We're doing a couple different probate phases. There's really four phases in the probate process here in Florida, at least. We've got an episode, on the other ones, but this is the second stage, and this is probably the most time consuming for you, the client. It's also probably one of the most important pieces of the probate, because we're getting the personal representative, we're getting the what's called the executor, or personal representative or administrator, depending on your state. In Florida, we use the term personal representative, but we're getting them appointed by the court. If there's a will, we're taking the will to court, and the judge is going to rule on it. So this is really the initial stages. And if you haven't, I'm kind of reading from a copy of my book here. A loved one has died. Now what? If you want a copy, just email me. You can email me personally at justin@probatefirm.com, and we'll send you a copy of that. So this is really where, in phase one, we were talking about, leading up to this, gathering the information, getting everything together, making sure everybody's on the same page, if that's possible, trying to locate things, making sure the house is safe if there is one, notifying banks if we need to notify banks. But at this point, stage two, what we're doing is, now we've got everything together, we're going to prepare some documents, and we're going to start the case. Again, this is probably for the most part, for most probates that are quote unquote simple, and I hate to use that term because sometimes they turn out not to be so simple. But for the quote unquote simple ones, you really are not going to have to, you as the representative are really not going to have to do that much. This first piece of it is just, you're going to have to sign some documents. If you're working with us, we use electronic signatures. So we send them to your phone, your computer, your email, and you can sign it there. There are, however, a couple documents that have to be notarized, which is probably the most time consuming. But other than that, it's pretty straightforward. So in this book, I list the documents that we're going to file probably in each one. So the petition for formal administration, affidavit of heirs, and some other stuff. I won't read all of them, but it kind of lists out everything that we need to get filed. The important thing about this is where I see a lot of probates get hung up and get stuck, because what they do is, or the attorney or the person filing it, if they're filing it themselves, if they're trying to do it themselves, pro se is what we call that, they are maybe missing a document, or maybe something is done incorrectly. Maybe they got a form online, and maybe that form was good for 2019, but as of recording this, we're in 2020, and maybe in 2020 it doesn't have certain language that's needed by the court. And so the clerk, the person in the courthouse who's receiving all of the documents, is likely going to say there's some sort of error. And they may not even tell you specifically what's wrong. They just might say, hey, this wasn't done properly. And so what happens is, this ends up sitting, you file all this paperwork, and you want to get in front of the judge, or you're asking the judge to sign what's called order appointing personal representative, and orders and letters of administration, and they just sit there forever. So this is where you really have to be persistent. One of the things I think we do really well at our office is we just have people borderline just harassing the clerk, calling all day, every day, saying, hey, what's the status? What's the status? What's the status? And sometimes that's what it takes. Sometimes it just takes constant follow-up, which is, again, why a lot of people don't want to do this themselves, because they don't have the time to call. They're not even really sure what questions to ask. But even other attorneys, you got to have staff and people who are going to be able to do this. You want to have good relationships with some of those people as well. So this stage, again, what I call stage two, we're getting a case number. So we're going to prepare all of those documents for you. We send you the documents, you get them signed, you get them notarized, you send them back to us, and we send them to the court. And the court is going to give us a case number, basically a case number, a number is going to be assigned to your specific probate. And the next step is we've got to get what I mentioned a little bit ago: order appointing personal representative, letters of administration, and a third one, generally, order designating depository. So let me explain what those are. The order appointing personal representative, what that document is, it's naming who's going to be in charge of this estate. So who can sign documents? Who can go to the bank and request that the bank account be closed out? Who can sign a listing agreement with the real estate agent so that they can list the property? Once there is a sales contract, who can sign the contract? This is generally going to be the personal representative. Again, some states use the term executor, but in Florida, we use the term personal representative. This is also the person who gets to kind of control the probate. It's the person in charge. So it's before we can do anything else, we have to have the representative appointed. And one thing, there's a lot of misinformation out there, is just because you are named as the representative in the will doesn't actually make you the representative until the judge signs a piece of paper saying that you are a representative. Okay, so even if you've got a copy of mom's will, and mom's will says you get to be the representative, we're going to have to take that will to court. The judge is going to have to say that it's a valid will and name that person as the representative. And real quickly, why? Let's say there's two wills, and one of the will names somebody and one of the will names somebody else, or maybe the will wasn't valid. So that's why the court, the judge, they want to see everything, and then the judge, he or she, is going to sign an order appointing personal representative saying who's going to be in control of everything. We're also going to ask for letters of administration. These are, it's a document signed by the judge that allows you, the representative, to work on behalf of the estate. Most of the time, if you're trying to get money from a bank account or a life insurance policy or something like that, they're going to ask you for letters of administration. They might say letters testamentary, something along those lines. We just kind of call them letters. That's what we're going to get during this stage. And then the last document which we get is an order appointing or order designating a restricted depository. And what that is we generally have to open up, or possibly have to open up, a bank account that is a restricted account, meaning we can only put money into it, but we can't take money out unless the judge allows us. So for example, if mom passes away and she's got $50,000 in a Bank of America account, we're going to have to take that $50,000 out of the Bank of America account, put it into another restricted account that we've opened at probably a different bank. And so this order designating depository allows the bank to open up the account. So I won't go too much into that one in this episode, but just when there's money involved, we generally, it depends on the county in Florida. Some counties require it, some don't. But depending on the county, we're going to have to open up an account, put the money into that, and that money is going to sit there more or less until the probate is over. And then the judge will give us a piece of paper saying we can really disperse the money to the heirs. So those are the three things that we got to get signed: order appointing personal representative, letters of administration, and order designating depository. Before we get those three things, we really can't do too much in the probate. So that's why there's kind of a rush to get it done. On average, it takes about 30 days to get all of those documents signed. It can be a little bit sooner, it can be a little bit later, but it really depends on the county, it depends on the judge, and depends on some other factors. But in our experience, we do a lot of these. I say it's usually between 30 and 45 days on average. Some things you can do to go a little bit quicker. If there's other heirs, if there's other siblings, other people involved, we can get them to sign what's called a waiver, which basically says, hey, I'm going to let my brother be the personal representative. I don't have any issue with that. They sign that waiver, and that helps expedite the process a little bit. But I say on average, about 30 days. Again, stuff can happen. I've seen crazy stuff where, another brother shows up and he's got one will, and a long distance relative shows up and she's got another will. So a lot of different things can happen, but that's why I say it's about, 30 to 45 days. This is really, again, phase one got us to be able to prepare all of the documents. Phase two, we prepared all the documents. You or whoever has now been named as the representative. Now we're ready to go. And that's where your work, if you're the representative, is it kind of stops. You're still going to have to, do some things, but once you get appointed as a representative, now we're off to the races. Now we can start trying to locate if there was other assets, if there was other money. Now we can get a listing agreement and potentially try to sell any of the real estate. Now we can, if there's creditors that we need to pay off, we can start talking about negotiating some sort of payoff, or fighting them to not pay them anything. So first stage, depends on how long, there's really no time limit on that. Just once you're ready to start the process. And then once we've got the probate filed, about 30 to 45 days to have the representative appointed. And now we'll go into stage three, which is locating assets and notifying creditors and dealing with any creditors.